Any mention?
May it please your Lordship.
Yes.
I beg to mention item number 14, Lordship. 11 and 14.
One by one. Just come to 11 first.
They connected, Lordship.
Yes.
11 and 14 are connected, Lordship. We are praying for 2 weeks' time.
For the petitioner, Your Lordship.
No objection.
No objection.
No objection. Okay. You are appealing for the state.
Lordship.
Just one request made on behalf of
State respondents and 14
on behalf of the state respondents. This is matter after 2.
After 2 weeks, Lordship. Lordship, in item number 11,
we are state respondents.
we are the state respondents, Lordship. And item number 14, we are the petitioner.
Okay, we record it accordingly. 14 days. Yes.
Much obliged, Lordship.
May I please, Your Lordship? Your Lordship, I beg to mention item number 15 and 16, Your Lordship. This matter is still pending before the Honorable Supreme Court, Your Lordship.
The 15 and 16.
Yes, Your Lordship.
Both matters
Are connected.
are awaiting disposal.
My lord.
So, that is already been recorded in this
My
order
lord,
earlier.
yes, there is a record. There is orders been passed on this submission. also.
Basing on the submission made
My
by
lord.
you on that. So you just write the same order on the previous thing. Just say on the under counsel for the appearing to the party submit that the connected matter pending before the apex court is yet to be disposed of. So in view of the submission made. When do you want it?
After 4 weeks.
After 4 weeks, my lord.
This matter after 4 weeks. Yes. Check the previous order and then.
Please, Lordship.
Yes.
Lordship, I beg to mention item number 17, Lordship.
Yes.
Lordship, I pray for 2 weeks, Lordship.
Which is the other side?
No objection, Your Lordship. I'm preparing for the sole respondent, Your Lordship.
Yes. Just say 17. One prayer made on behalf of the petitioner. This is matter after 2 weeks.
Much obliged.
May it please, Lordship.
Yes.
I'd like to mention item 9.
Item 9.
I pray for 2 weeks' time, Lordship. No objection, Your Lordship.
And just say one prayer made on behalf of the petitioner, not objected to by the learned state, the learned council appearing for the state respondents. Learned GA appearing for the state respondents. This is matter after 2 weeks.
Lordship.
Much obliged, Lordship.
Lordship, similar prayer for item 18, Your Lordship.
Yes, Mr. Ahmed.
No objection.
Did you also? Second, one prayer made on behalf of the petitioner, not objected to the learned. After 2 weeks.
2 weeks.
Obliged, Lordship.
Much obliged.
Be it please, Your Lordship, I beg to mention item number 20, Your Lordship. The conducting council is indisposed, Your Lordship. I pray that the matter may come up after 2 weeks, Your Lordship.
Prayer made on behalf of the petitioner, list after 2 weeks. Yes.
Highly authorized.
My lord, I beg to mention item number 7. I'm praying for 2 weeks' time, man.
Item
7.
7. Yes. What is this?
My lord,
Service
that is
matter.
that reservation, my lord. I'm waiting for instruction, my lord.
Yes, my phone. That is 1% or 2%.
My
Why it's taking so long for taking small instruction?
I may be given last opportunity 3 weeks, man.
See, the thing is that the thing is that why? What is the difficulty? It is not that something has to be, you see, like a formula has to
Exactly,
be
exactly.
struck out and all those things. You have to take. See, giving last chance is something like stopping you these things.
Right.
If your instruction helps the court dispose of the matter, then definitely we welcome that. But then, you see, it should not be something
Mine.
like. Okay, just say straight for on the prayer made on
3 weeks, man.
behalf of the 3 weeks. All right, Mr. Paul.
My lord.
On behalf on request made by Mr. Guru Landip GA, appearing on behalf of the state respondents. Say further 3 weeks time is granted to obtain necessary instruction on the matter.
Prepare.
May I please? Item number 25. Pray for 3 weeks time. Item number 25.
25.
Yeah,
Yes.
connected matter is pending before the DS.
It's quashing.
4 weeks. 4 weeks on the request made by the and request made on behalf of the petitioner. Yes.
Yes, Lordship.
Yes.
Lordship, I beg to mention item number 8, Lordship.
No, Lordship.
Yes. What is your prayer?
Lordship, if matter appears matter will come up after 2 weeks, Lordship.
Yes. Any objection with the petitioner?
No objection, Lordship.
Just say on request made on behalf of the state respondents, not objected to by the learned counsel for the petition, restricted to this. Yes.
Lordship, Lodge.
Yes, Your Lordship, Your Lordship, I beg to mention item number 23. I pray this matter may come after 2 weeks, Your Lordship.
No objection, Lordship.
This is a request on behalf of the appellant.
Yes, Your Lordship.
On prayer made on behalf of the appellant. This is matter after 2 weeks.
2 weeks, Lordship.
Yes.
Much obliged, Lordship.
Supplementary causes, item number 1.
With the books. No, please, Malaj.
Yes.
This is an application seeking quashing of Malaj proceeding as well as an order passed by the learned judicial magistrate first class, Malaj. What had happened is, Malaj, some complaint has been filed before the judicial magistrate at Nongpo. CR case, Malaj. Now, without Malaj considering the provisions of law, if I can just take your lordship to annex 2, page 22. This is the orders passed therein, which is assailed before your lordships.
Yes.
My lords, this is the order dated 28/4/2024. If I may turn, my lords, these are the where the court states that, my lords, the statement has been recorded. I'll read from paras 6 and 7, my lords. The allegations made in the complaint prima facie disclose commission of offences involving breach of trust, cheating, forgery, and misappropriation of property intended for the welfare of the complainant and her brother Alan Donald Sopadang, amongst others. At this stage, therefore, there are sufficient materials to proceed against the accused persons. Thus, a prima facie case is made out against the accused persons. Now, next page, my lords. Accordingly, this court takes cognizance of the offences, issue summons to the accused persons. Now, as your lordships are aware, my lords, I'll just place the law. My lords, if my lords kindly have section 223 of the BNSS now, my lords.
Section
223, my lords. That is corresponding to section 200 of the old code of the CRPC.
Yes.
My lords, may I just read, my lords? Examination of complainant. A magistrate having jurisdiction while taking cognizance of an offence on the complaint shall examine upon oath the complainant and the witnesses present, if any, and the substance of such examination shall be reduced to writing and shall be signed by the complainant and the witnesses and also by the magistrate. Now, there's this proviso which has now been inserted, my lords. Provided that no cognizance of an offence shall be taken by the magistrate without giving the accused an opportunity of being heard. The lordships would have seen, my lords, that the court proceeds to take cognizance without even, my lords, first issuing any notice to me.
So that proviso appears to be mandatory, isn't it?
Yes, my lords. And, my lords, this is in contradiction to the earlier provision of section 200. This proviso was not there. So this is an insertion under the new code, my lords.
Then what happens before the say like if a CR case is filed?
My lords.
The court has to issue process before
Before taking cognizance, and hear me, my lords. It's a mechanism to check, my lords, any kind of false litigation or frivolous litigation.
So that is say like one layer of protection, extra layer of protection given.
My lords. Okay. Other than that, also, my lords, 225 provides, as your lordships are aware, that if it is outside the jurisdiction of the court concerned, my lords, deferment of the issuance of process.
But then that is again, you see, it can be corrected. So that is what the
lordships.
Anyway, right now, I will just. Any interim prayer?
My lords, there is a place. Because this order is prima facie bad in law.
Are you pressing for interim here?
Prima facie bad in law.
Hard Mr. Keppel. Senior counsel assisted by the paying to the petitioner into notice returnable in 3 weeks. The petitioner, oh, there are more than one petitioner.
There's 3 petitioners.
Landed counsel for the petitioners. The petitioner shall take step for service of notice upon the sole respondent within 2 days. Then just say give paragraph. The perusal of the impugned order dated
28th of April, Millets. 28/4/2025.
It is of the magistrate first class in complaint in this is what is
CR
this?
case number 93 bracketed T of 2024.
That
Millets.
is small t.
It's capital T, Millets. I'm sorry.
But then here, no, but then even the
Achha, I'm sorry, Millets. It's small t. I think, but it should be capital T.
whether
Millets.
the t should come before 93 or it should be after 93. Now in the order sheet, if you see CR complaint
My lords.
T93 2024. You see, like it is about correctly mentioning anyway.
That's just
Whatever way you say, we'll record it that way.
My lords, it is complaint T93 of 2024. my lords. At page 21A, if my lords kindly have a look, this is the summon that is issued, my lords.
Yes, but the same number is there in page 22 also.
Lordship. my lords.
Yes, just see page 22. Case number is given there, and then take from there. Okay, just say what you said. Passed by the magistrate first class, River district in CR complaint number so and so. Just give it. It appears that the landed court has taken cognizance of the complaint without adhering to the proviso to section 223 BNS. Stop. Give paragraph in view of the above, the and just see what he said without just before that we just previous do not say in view of the last part. Landed court has taken cognizance of the matter. Stop. And proceeded to issue summons to the accused persons. They proceeded to issue summons to the petitioners herein. Just say them say. Just say since the non-compliance of the provision of law is apparent, comma. We'll just take the further proceedings or
My lords.
yes, further proceeding of the order dated 28/4/2025 and further proceedings of CR complaint T number T93 of 2024 shall remain stayed till the return
My lords. Highly obliged.
Item number
list
2.
after 3 weeks. Yes,
May I please, Your Lordship?
yes.
Lordship, here I am aggrieved by the illegal and arbitrary termination. Your
Permission
Lordship,
for the post of
I was working as in the master role as unskilled labor in the office of the executive engineer, Nongpo, since 2013. Your Lordship, and I have been rendering service till date. It is only in the month of February that my salary, I didn't receive my salary, so I went to the office and I came to know that I have been terminated. and a new person has been engaged.
Where is your appointment?
Your Lordship, at Annexure 1,
Yes.
this is my participation in all the training
No,
programs.
your appointment. Your appointment. Your engagement or appointment.
In master role, actually, Your Lordship, they maintain a
No,
register.
but then see, there is an order of engagement. Where is that?
Your Lordship, if my
There is no such thing. There is no such thing.
there is
So
no
far as you are
appointment
concerned, okay, then where is your termination?
there is no termination. Your Lordship.
Then where is the appointment of the other person? And
It is only when I went there I came to know, Your Lordship. I filed a representation to that
It's
effect.
very
Also.
difficult, Mr. Paske, to prima facie see that thing.
Your Lordship, if my Lordship comes to
Have you made this new appointee party?
No, Your Lordship.
Will issue notice? Yes, you take
Your
offense.
Lordship, because in para he has specifically stated that someone has been replaced.
Who is that someone and on
Yes,
which
that
date
but
he came?
that person has not
And
been
we
added as a
must-
party, and he is a necessary party,
And
Lordship.
we must see that whether he is at all
Yes,
appointed.
and no appointment and no termination order.
Your Lordship, I should also know the name of who has been appointed. If I am unaware
So
of
see,
the
like,
fact.
you come to court, that is basically your duty to proceed before the court.
Lord-
Anyway, we'll issue notice, let us just nothing more than that. Heard, Mr. Paske, Learned Counsel for the petitioner. Issue notice. Returnable in 3 weeks. Mr. Sheikh Learned GA appears
For all.
the respondents. Hence, no further notice is called for.
Deeply obliged. Your
The
Lordship.
learned, next person, the learned GA shall obtain necessary instruction in the matter. List after 3 weeks.
Deeply obliged. Your Lordship.
See, and you have to, if you say somebody has been appointed, then he should be a necessary party, because any order passed by this court would affect him, will have a bearing. Just see, think about it, it is your thing.
The list, item number 1.
Yes, you are supposed to file objection. Who?
I've already filed affidavit.
Yes. So, have you received a copy?
Yes, yes.
So, matter can go for hearing.
Yes, yes, Your Lordship, all the pleadings are completed.
MS Jetty submit. Appearing with the rest number 3 submits
To respond.
that the objection on behalf of the said respondent has already been filed. Give stop paragraph. The parties, learned counsel for the parties submit the matter is ready for hearing. Stop. Just wait for list after 3 weeks for hearing.
Deeply obliged, Your Lordship.
Item number 2.
Please, Lordship.
Yes.
Lordship, some time is required to file our objection, Lordship. Can you allow us 2 weeks' time, Lordship?
No objection, Your Lordship. In the meantime, Lordship, the interim stay in the miss case. We continue.
There is
I won't be filing any objection.
You won't be filing any objection. You are appearing for?
I am appearing for respondent number 2. I am a pro forma respondent, Your Lordship.
Okay. Yes, sir, Mr. Kharkhan, Lord Counsel appearing for the respondent number 1. Or rather, before that, you say MS.
TC member.
Sorry, I just forget names very fast. Landed Council appearing others number 2 submits that no objection will be filed on behalf of the state respondent. Stuff. Then you say Mr. Karkang, Landed Council appearing to the respondent number 1. Please for grant of some more time for filing objection in this matter. Yes, sir. Prayer allowed. List after
2 weeks, Lordship.
and in the miss case. Where is the miss case? This is miss case 25. What is the order sheet? Is there any order sheet? Yes, just say list. Just matter after 2 weeks. Interim order passed after. Just say list along with the main case. Just say list along with the main case after 2 weeks. Comma interim order passed earlier. Shall. So we'll. What is the question of extending this interim order in piecemeal? We'll make it until further order.
Yes, Lordship.
Then we can dispose of the miss case then.
Your Lordship.
Anyway, disposal will be in your favor. Anyway, forget it. Just say the interim order passed earlier shall continue till the next day. Yes.
Item number 4.
My lord,
Yes, Mr. Jan.
May I please your Lordship. Lordship, learned DSGI is on legs before courtroom number 2, Lordship. Learned DSGI is on legs before courtroom number 2, Lordship.
So what is to be done?
Lordship, I pray for 1 week's time.
Jan, what is to be done?
My lord, without the DSGI, my lord.
You can understand there is a difficulty, but then if that becomes a regular feature, then again it's a problem. Just say on prayer made on behalf of honest DSGI. Not objected to by Mr. Arjal Learned Counsel for the petitioner. This is matter after a week. Make sure, madam, this is taken up. This at least adjournment on those plea now may not allow on the next.
Lordship.
This court basically tries to accommodate everyone, but then if it becomes a regular feature, then it is very difficult.
Much obliged, Lordship.
Item number 10.
Yes.
Your Lordship can have this matter after 2 weeks, Your Lordship.
What is this matter about? Service matter?
Yes, Your Lordship.
Promotion?
Challenging the selection process.
Appointment?
Yes, Your Lordship.
You have not been appointed. You took part in the selection process?
Yes, Your Lordship.
Yes.
I appear for respondent number 1 and 2, my lord.
Just record this thing on prayer made on behalf of the petitioner, not object to the Learned Counsel appearing for the respondents. This is matter after 2 weeks.
Item number 12.
This item 12, my lord, we are basically agreed by the impugned order dated 27/9, my lord, 2029. Now, what had happened here, my lord, my predecessor in interest, my lord, was allotted with a certain plot of land in Forest Colony.
This is a writ petition with regard to land matter.
Seeking resumption of, against the resumption of land by the Forest Department, my lord.
Land revenue regulation?
Yes, my lord. I'll take your lordship to. Now, this is the second round of litigation, my lord. In the earlier round, my lord, there were certain letters issued to us. Now, against that, my lord, we had moved this honorable court. And your lordship was pleased to pass an order, which your lordship will find at page 16.
Page 16.
Right, no.
The page 16 is the schedule only. What?
No.
It's a schedule of land.
Let's bring the counselors. Page 16 is an order in my. Is an order passed in writ petition number 251 of 2029. 2019.
No, it is not there. Page 16 here, it's a part of schedule of a deed, I think.
16 is the
order.
There is some mistake with the copy.
Pagination here.
But 16, yes. 16 here is the order of the Honorable Court dated 14/8/2019.
This is Iftikharuddin, isn't it?
No, no.
Writ petition number 422.
No, my lord, this is Dibjani.
423, my lord.
This is what? Which item? This is item number 12.
My lord, next item is 420. Sorry, I was referring to the next item, 423.
Right now we are with this
My lord,
item 12.
my lord, I would request that 423 be taken up because This is the second round of litigation, and in this particular litigation,
what is the connection between these two matters?
because my lord, it pertains to the land in the same
are forest
vicinity,
lands, my lord.
same area. My lord.
No, but that is okay. Are they affected by the same order?
Not well, subsequently the similar kind of orders were
Why
issued.
it is stacked together? This will basically create complication. Is it not that this is not that the order passed in one case will cover up the issue involved in the other? It may have bearing. Stacked together, I can understand. Why it is stacked together? There is anything.
These are all belonging to the forest colony animals. Where the forest department are not.
Essentially the same. I mean, no, but then these are different orders under challenge.
Different orders, different dates, but similar orders.
Anyway, then what do you want us to take up? This item?
No, item 423,
Now,
sorry,
so far as this
number
item
4.
is concerned, you are referring to a High Court's order passed in the earlier round of
Yes,
litigation.
yes, ma'am.
But then that is not there in
These
the.
writ petitions were not there in the earlier round of
This is only
litigation.
mere direction
So
to dispose
the
the
situation also is not identical. Then. Not very
In
similar.
earlier round, my lord,
Anyway,
some
revert
of
to
them
page
were
16.
there, some of them were not there, my lord.
Yes, page 16. Come to page 16.
Lord, I'll take your lordship straight to para 4.
Yes.
After hearing the learned counsel for the parties and perusing the writ petition without expressing any opinion on the merits of the controversy and the issues raised in the writ petition, the same is disposed of at this stage by permitting the petitioner to file a detailed and comprehensive representation against Annexure 10 before respondent number 2 within 15 days. It is, however, clarified that in case such a representation is filed, respondent number 2 shall pass a speaking order thereof within next 1 month after affording opportunity of hearing to the petitioner interested party in accordance with law. Now, my lord, following this, there was an order passed by them, which your lordship will find at page 22.
This is against order of eviction, isn't it?
The
The order was passed against the order of eviction. The challenge in the earlier
basically
round of
directing us to
litigation
vacate the premises, my lord.
That is what.
Now, I'll take your lordship straight to page 32, my lord. In view of the facts and legal position as stated in the foregoing paras, it is clear that.
Just a minute. Page 32.
My lord.
That is the operative part.
Right.
Yes.
My lord, in view of the facts and legal position as stated in the foregoing paras, it is clear that the applicant so-and-so or her so-and-so have no right whatsoever on the said plot of land in short round PF Shillong for any kind of occupation, either temporary or permanent, or any kind of lease or extension thereof. The notice issued by the Divisional Forest Officer, White, later dated so-and-so, is hereby affirmed and upheld, and the representation of the applicant dated so-and-so addressed to the DFO is rejected as being bereft of merit and substance. The applicant and her so-and-so are directed to comply with the aforesaid notice issued by so-and-so and vacate the premise immediately. Now, my lord, the premise on which we have approached this honorable court, my lord, is my lord, violation of Article 14. And why I see this, my lord, the particular area where I am in occupation of the land.
What is the remedy? This is the order. It is passed under what? What authority? This is, say, supposing this is there no other remedy available? Is that?
No, my lord. There's an appellate authority, my lord, who has passed this order. There's a remedy of appeal, my lord.
Yes.
We've preferred an appeal by way of a representation. That stands rejected by way of this order.
Achha, that is an order passed in appeal.
Right, my lord.
So what is the question of filing a representation before the appellate authority as ordered by this court? See, like the order passed.
Earlier round, my lord, we said that, my lord, the impugned letter then was issued without hearing us. Now, in such a backdrop, my lord, that order came to be passed in the earlier round.
And that is why you see, like it seemed like the High Court at that point of time disposed the matter by giving you an opportunity to file a representation,
Right.
which you did accordingly.
Madam.
Now, can it be said that that was done in exercise of appellate jurisdiction by the authority concerned? Or it was just because of the special opportunity created by High Court's order?
My lord, there is a provision for appeal, my lord, before the DFO only.
So then what? We do not know then. Then what purpose basically that earlier
No,
order?
my lord, the action against which we have come before your lordship is purely, my lord, arbitrary and illegal and in violation of Article 14. Why? Well, I'll buttress and I'll substantiate why I say so, my lord. Because here, the particular area where I am in possession of the particular land, my lord, there are a number of households, my lord, who has taken the land on lease. Now, what the respondent have basically chose to do, my lord, is to cherry pick people and issue this kind of a notice. And there are people who are holding land in the same vicinity, my lord.
Is it, well, do not know. There's a,
No, this will be under the Meghalaya Forest ejectment of unauthorized.
yes, but then does it relate to,
Or how-
probably as a government council, this court had also appeared in a similar matter, the property in Short Round Road.
Right.
And then
I think Melons had appeared in one
some
of the
Pimpa
matters. We were the
Marwani and-
petitioners.
see, like,
Your lordship is correct.
now after you are making submission, in such a case probably it may not be proper for this court to.
The land, my
That is-
lord.
And then probably it was your case, Mister.
Well, they've
But
generally
then not for,
maybe-
no, not,
These are all connected matters, Lords, I think. This isn't that matter.
Same area, my
of
lord.
course, not sure, but the vaguely court vaguely remembers that.
I am also very vaguely remembering.
So then we should be correct. Then we'll do it. We'll say that it should be listed before some other bench. This is not recused by any other bench, isn't it? Matter is not recused by.
No.
We just say this item 423. Then 422 also will go.
No, that is.
These are all connected.
And that, you are there in that 422. No.
No, my lord.
153.
So all these connected matters. Yes. All these connected matters. You just say list is matter.
Item 12 and 13.
Item 12. Okay. Just say list is matter before any other bench without me just writing these things. Because this court remembers that, you see, like, again, it's a similar thing because he appeared, may not be for these petitioners, but there are some other parties.
There's these connected matters, Lords.
Yes.
19.
Yes.
This is that matter which my lords have heard on many occasions, my lords. We are on a sticky wicket on this. We had filed that application under 311 for reducing additional evidence, my lords, and that was rejected by the court. I am, my lords, on a very sticky wicket on this. My only submission would be, my lords, that otherwise there is, your lordships have read the order of the learned Sessions Court. There's nothing much that can be interfered with. But we have, however, come across one decision of the Honorable Supreme Court, which is a very recent decision, my lords. I'll just, you've taken out the TIR? Copies for the court. Paragraph? Para 123.
You are in a revision of jurisdiction, Mr. Paul.
Well,
The limited
Scope is very
very
restricted, my lords. Well, I'll just read it, Well, it's a very small paragraph. This is, well, it's a 2023 decision. And, well, it says, Section 311 CRPC confers wide powers on the court at any stage of an inquiry or trial or proceeding under the code to summon material witness or examine person present. Such person may not be a person summoned as a witness. Power to recall and re-examine is also vested. The concept is that it should be essential for the just decision of the case. The said decision is reproduced, section is reproduced below, my lords. This power can be exercised not only by the trial court but also by the appellate or revisional court. The logic behind this provision is that the endeavor of the courts is to find out the truth, which would be essential for the just decision.
That is okay. That is coupled with Section 391 also. You see, the appellate court has the power to...
Power.
Yes, so that is there. There is no dispute to it.
The only thing is, well, it's here what had happened is, well, it's the evidence has been closed, admittedly, well, it's, 313 is also done. Now, at this stage, well, it's what the petitioner says that he wanted to raise a plea of alibi, which, well, it's, he says that I can cross-examine certain witnesses to establish the plea of alibi. That's the limited issue with your lordship. Well, it's, other than that, there is nothing. But the learned court below has dealt with it.
Definitely, that is the main thing.
I must say, well, it's, I'm on a...
What is to be done then? Then you proceed, allow the court to go ahead with the finish the trial.
Well, its trial is proceeding in any case. Well, there's no interim orders passed by this honorable court.
Because this is quite a detailed order, Mr.
It is, well, it is.
Until and unless you show that the court has recorded finding without any materials, then only maybe.
I am unable to satisfy your lordships on that. Well, I have examined the matter. I am unable to do that.
Yes, Mr. Yes. What you wanted to say?
My lord, the hearing, only filing hearing, my lord, is not taking place because of this instant matter, my lord. Otherwise, everything is over. In fact, my lord, this is the second round the petitioner has approached this honorable court. Earlier round, my lord,
We have seen these things orders, and then there are some marked person probably it was heard also before.
It has been heard at length.
There are many things and many observations which basically goes against it. So allow this matter to be this thing.
Well, we were only praying, well, that since there's this plea of alibi, well, it's a murder trial. Now, well, it's only a question of cross-examination of 3 witnesses. That entire process can be completed in a day.
We are not on this thing. The 311 is something you see like this should be like for ensuring fair trial.
Fair trial.
But then it should not be for the purpose of giving advantage to a party to delay the matter again and again. And if you see the order passed by the session court, your conduct is.
I bow down, man. I bow down. This is one of those matters.
Problem lies there.
Malaj, I bow down, which is why I say, Malaj.
Even the court said that there is suppression on your part in the earlier round of
litigation. I've read the order, Malaj. It's a very detailed order.
That is what.
It puts me in a catch-22 situation, Malaj. My only prayer before lordships is, Malaj, that entire exercise can be completed within a day's time. Because these are all local witnesses, Malaj.
See, like, would not like to pass that order. See, like this court basically would like to confine to.
Malaj, whatever on the law.
The limited scope which is created by
law.
Court is not very adventurous to go beyond the limit.
I bow down, Malaj.
So that is what the problem is. You think over and then you do not know whether, but then it's better you allow this thing.
My lords, may kindly have it on Monday, Malaj. There is nothing other than that, Malaj, I can argue before your lordships on this case.
If you ask for this, we will make an observation that pendency of this case should not bar the trial court.
Yes, yes. Proceed with the matter.
That is what we will make specific. You can convey it. Yes.
My lords, may have it on Monday. We can dispose of the matter on Monday. We'll ensure. There's no point keeping this matter pending before.
Disposal, even if you proceed today also, then we can. Why not? You see.
Well, it's as your lordships pointed out. Well, it's, we can just ponder upon it, well, and get back to your lordships on Monday. My lords, may kindly have it on Monday. We'll dispose of the matter on Monday. There is nothing more for me to place before your lordships. My lords, we had tried to impress upon your lordships.
It was heard before also, Mr. Paul. There appears to be some notings by the court also.
Yes, my lords had heard it at length.
And then the underlying portions are there.
Yes, yes. I had taken your lordships through the impugned order. And which is why I submit, my lords, that the learned court below has actually dealt with the issue in detail.
Your prayers allowed, you did not bring witness, there are many things.
It's page 91, my lords, the findings. Very damaging.
Even you see like page 79 of the, or just see paragraph 8.5.
8.5, my lords.
8.3, all those, see there are many parts. These are all underlined by the court here.
Now, may I just pray your lordships kindly have it on Monday, please. we'll
You
dispose
can
of it.
inform your counterpart that the court, there should not be any, this pendency, why this pendency is, pendency should not be taken as a bar for the proceedings. Okay, just say, one prayer made by the learned senior counsel for the petitioners. List is matter after a week. Just will have it after a week.
After that.
#21.
I'll do that.
I file a progress file, the other file. It's there.
Yes.
Your Lordship was pleased to hear us on the last occasion,
Is it?
Your Lordship, yes. And Your Lordships had inquired whether Your Lordship could go any further than the FIR in order to, and see whether there was any prima facie case for quashing of any criminal offence made out in the FIR, and that for that purpose, Your Lordship was only looking at the FIR. Then, Your Lordship, when we tried to bring Your Lordship to the other documents which were available, Your Lordship said, can I go beyond the FIR? So, Your Lordship, we
Yes,
had
see,
prayed
this
for
query-
time.
This query has come.
We had prayed for time to
Yes.
give us some time to enable us to satisfy this honourable court by bringing some authorities, Your Lordship. And some, Your Lordship, now we have found some authorities that when there is an investigation going on, Your Lordship, at the threshold, only on the basis of the FIR, the court can go beyond the FIR and see what are the evidence on the record and all that, and then pass an order.
Please pass it. This will be good.
But I think I'm submitting this, Your Lordship. This is State of UP. This is
This is Apex Court decision. This is
1996, Your Lordship, SCC, page 709. This is at para 11, Your Lordship.
page 705.
705,
Yes.
para 11, Your Lordship. The question is whether the High Court is right in its exercise of inherent power under Section 482 CRPC. It is thus settled law that the exercise of inherent power of the High Court is an exceptional one. Great care should be taken by the High Court before embarking to scrutinize the FIR, charge sheet, complaint in deciding whether the case is rarest of rare cases to scuttle the prosecution in its inception. It first has to get into the grip of the matter whether the allegations constitute the offence. It must be remembered that FIR is only an initiation to move the machinery and to investigate into cognizable offence. After the investigation is concluded and the charge sheet is laid, the prosecution produces the statements of the witnesses recorded under Section 161 of the Code in support of the charge sheet. At that stage, it is not the function of the court to weigh the pros and cons of the prosecution case or to consider necessity of strict compliance of the provisions which are considered mandatory and its effect of non-compliance. It would be done after the trial is concluded. The court has to prima facie consider from averments on the charge sheet and the statements of the witnesses on the record in support thereof where the court could take cognizance of the offence on that evidence and proceed further with the trial. If it reaches a conclusion that no cognizable offence is made out, no further act could be done except to quash the charge sheet, but only in exceptional cases. That is, in rarest of rare cases of malified initiation of the proceedings to wreak vengeance, process of criminal is availed of in laying a complaint or FIR itself does not disclose at all any cognizable offence. The court may embark upon the consideration thereof and exercise the power. When the remedy under Section 482 is available, the High Court would be loath and circumspect to exercise its extraordinary power under Article 226, since efficacious remedy under 482 of the Code is available. When the court exercises its inherent power under Section 482, the prime consideration would only be whether the exercise of power would advance the cause of justice. or it would be an abuse of the process of the court. When investigating officer spends considerable time to collect the evidence and places the charge sheet before the court, further action should not be short-circuited by resorting to exercise inherent power to quash the charge sheet. The social stability and order requires to be regulated by proceeding against the offender, as it is an offence against the society as a whole. This cardinal principle should always be kept in mind before embarking upon exercising inherent power. The accused involved in an economic offence destabilizes the economy and causes grave incursion on the economic planning of the state. When the legislature entrusts the power to the police officer to prevent organized commission of the offence or offences involving moral turpitude or crimes of grave nature, and are entrusted with power to investigate into the crime in intractable terrains and secretive manner in concert, greater circumspection and care and caution should be borne in mind by the High Court when it exercises its inherent power. Your Lordship, so my humble submission is this, Your Lordship, that Your Lordship is also at liberty to see other paper documents, especially when the investigation officer has recorded all the statements under section 161, this, that, Your Lordship.
This judgment doesn't say so. This judgment says only when the matter is charge sheeted.
No,
now your thing is not charge sheeted till now.
It is not charge.
This will be lawful for the court.
Okay, Your Lordship.
Now, see, the query was that.
Then, Your Lordship, it claims.
Just a minute. Just hold on.
Okay, Your Lordship.
The query was that in a matter when FIR is filed and charge sheet is yet to be lodged after investigation, can the court, while determining whether the FIR discloses any premise of offence or not, and look into other things which investigating officer has collected during the course of investigation? This judgment applies at the stage when charge sheet is filed. So that is basically this court
but Your
knows
Lordship,
about
this
that
court
proposition.
has also, this case has also said that the FIR is only an initiation to move the machinery and to investigate into cognizable offences. So we have to give an opportunity to the prosecution to investigate the matter, and it cannot be just curtailed and a short circuit.
Then what
short-circuited, Your
Then what
Lordship.
happens to the proposition laid down in Bhojanlal's case, where it has been provided that if FIR doesn't disclose any offence, then
Your
what
Lordship, there are some other cases also, Your Lordship, where it
That
says.
is where we have to make a balance. So please place it there.
Yes, I will now come to Captain Singh, Your Lordship.
So this is what basically doesn't help the query of the courts. And then, so these decisions you have not supplied to.
No, I have just made a photocopy, Your Lordship. Will give
This
it.
court will be needing. See, you all are senior counsel, so we must come to it.
This is the first judgment.
Then you do one thing. You please supply him a list of their cases.
But
Can
we
I-
have also not received any list of cases.
Cases from his side. also.
Mr. Jindal, it will be proper to exchange, please. Then you do one thing, kindly exchange, and then we will proceed with the hearing. Because since we are on a question of law,
Yes, Your Lordship.
that has to be clarified.
I'll give a list of book we can give it right now.
The list, we would also like the copies.
No copies to use outside.
Anyway, then you also exchange your list the same
Yeah.
like manner.
So we'll exchange
Here are
the
the four
list.
judgments you give us.
So we'll give you the list also.
These are like SCC. Is it available on mobile?
Please go through and come back to us so that it may happen that the court also will miss many things.
Yes, Your Lordship. No, so I can supply the other judgments
If you have
also.
access to each other's law point,
Then we are.
we'll get.
Then my friend here.
Because this is a question this court has put in some other matters also. I think Mr. Chakraborty is appearing that case.
Mr. Sulai also.
Mr. Sulai, Mr. Sulai also,
In that case, it was charge
some
sheeted.
other matter.
It
he
was
has
charge sheeted.
placed a decision like what this madam has played just now.
This
But,
applies to the charge sheet, Your Lordship.
This
I
applies-
have the specific judgments only where is the FIR was there, nothing else. And the plea was raised that the court could look into the other aspect, and that contention was not agreed upon by the. So those are latest judgment of. I have a judgment of 2024.
Your Lordship, may kindly appreciate the fact that, Your Lordship, the FIR, after the FIR was lodged, Your Lordship, investigation has already started, Your Lordship. And we have almost come to the end. We have almost come to the end. Statement of the witnesses have been recorded, Your Lordship.
We understand,
So,
we
Your
appreciate
Lordship,
that.
my prayer is that, Your Lordship, if I may be allowed to complete, Your Lordship, that the option for the petitioners that they can go to the trial court and pray for discharge if they are in any case aggrieved.
We can understand that. But then
Discharge
that stage has not
at
reached
this
till
stage,
now.
Your Lordship, I
a
think
minute,
it's
a minute,
premature.
a minute. You are talking about discharge. Discharge will come only after a matter is charge sheet.
Charge sheeted.
But then here the petitioner wants to get rid of the hassle of the
FIR.
investigation. Hassle of the investigation. And the law permits. It is not the impermissible situation that the no FIR can be quashed. No FIR can be quashed provided the certain condition, fulfillment of condition, and
Fulfillment
which
of this condition.
basically starts from Bhajanlal's case. Okay, that is the landmark decision which till date has been
The
held.
grey area in the Bhajanlal case was this, that Bhajanlal case has not dealt with the query which my lord has.
No, that is, see, like law is certain thing, it depends on situation, the many thing comes. We are also facing, because this court has basically taken note of what has the point which has been placed by this, that yes, if it is charge sheeted, then the situation takes a different turn.
The
Then in
matter
such a
could
case,
have
it will
been
be-
charge sheeted,
It will
Your
be permissible for the court to go through the statement of 161 and other materials on record to decide whether there is a prima facie
facie
disclosure and whether the court should exercise 482 or not.
The matter
So
could
there is
not
no
even
dispute
be.
with this thing. There remains no confusion. The confusion is with regard to the stage we are at. We are now. That FIR has been filed.
Yes.
Maybe proceeding has continued somewhere. Now prosecution wants this court to take into cognizance some other materials which has been collecting during the course of investigation.
Which are even
Now,
not.
whether law permits us to do it or not.
Yes, that is the only point. That's the only point.
In fact, we are in the verge of completing the investigation, but because of a stay granted by this honourable court,
question
investigation has been stayed, Your
come
Lordship.
into picture.
Investigation has been stayed here.
Yes, Your Lordship. In
Is
this
there? Is it?
Tura PS case number 23, it has been stayed.
Okay. Investigation has been stayed.
No,
Yes,
no.
Your
There,
Lordship.
In this
so far,
order
my
filed by this
my
court.
my
Yes, Your
instructions are there. There is no stay order.
There is a stay order, Your Lordship, because I've been appearing.
No, no.
Let us
This
see, let
court
us see
has
the
not passed any
order
stay
should-
order
order
in
should
this
be-
matter.
But it is this
In
Tura
other matter, it
PS
was there,
case number has
which
been.
I have withdrawn.
The same FIR, my lord.
Same FIR, the same PS case has been
Where is the-
stayed, Your
where
Lordship.
is
The
the
investigation of this case has been stayed.
Where is that order? Please place
Anyway,
this
Your
order.
Lordship, since Your Lordship is saying that after we.
Please have the exchange because since your question
Yes.
is low. But then where is the stay order? Just give it to us. Let us see.
My lord, in CRP, KT7 and
Just place us. What is the difficulty in placing a copy of the order? CRP is
No, in this case, Your Lordship, there are three cases
Yes.
emanating out of this FIR, Your Lordship. Now, two of the accused persons are the employees of the Garo Hills Autonomous District Councils, Your Lordship. They were also impleaded as accused
there
persons.
a conspiracy. There's conspiracy.
Yes, there is a conspiracy, and so these three cases are related, Your Lordship, interconnected. Now, in 89, 87, it has been stayed, Your Lordship.
Not in this case, Your Lordship.
But
That's
this
what
is the same
they are
FIR,
not telling
the
correct
same
thing.
police case.
They should tell the
It
correct
was
thing. That this
registered.
Anyway, Mr. Jindal,
The same
if this
police
investigation
case.
stayed in
The
by
same
virtue of
police
the order
case has
passed in
been
other case,
registered.
then that will have the consequence of this thing. Also.
Yes, that
Can
is
you
why
just-
we couldn't
just
proceed.
have this thing will the
So
have the
I pray, Your
exchange
Lordship,
things?
that even the other cases may be tagged together and we can dispose it off together, Your Lordship.
Is it?
Because
Is
the
it-
FIR
cannot be,
is
Your
the
Lordship,
same.
because
Same FIR, same police
the
case.
accused persons are different.
Yeah, only the accused
Allegations are
persons
different. Allegations are different.
According to Mr. Jindal, this is purely a civil matter. You should go to a civil court, establish your title, and you take it. Probably in those
This is
matters,
not
it
a
is not.
civil matter
It's
at
not
all.
there.
Anyway, you have these things. Exchange the authorities. So to be done.
We take it on Monday, my Lordship.
We will have it next week, Monday.
Monday.
No, Monday will be too short, Your Lordship. Today is already Thursday, Friday.
only
You are already prepared. It seems you are already prepared.
You are always here in the VC.
VC is not very.
So remain here. Shillong has very nice weather. Enjoy it.
Next week, which date you can come, you give your date.
Yes. When would it be
After a
convenient for
week's
you, Mr.
time.
Paske? After a week. So we'll have it after a week. Monday to another 3 days maybe. 3 days.
Your Lordship.
Yes. The
My friend is very
okay,
accommodating.
the learned counsel for the parties shall exchange
Sir.
the list of authorities sought to be relied on by them in this matter. So to be read on by then, before the matter is taken up for final hearing. Stop. Then you say as spread forward the parties, list this matter after 1 week. We'll just finish it.
Your
See,
Lordship, some judgments are running more than 150 pages. Can we do the relevant paras and give it to the other side?
You just give the citation list, exchange the list. They will see of their
List I have given today.
I have received the
So
list.
then
Your
let
Lordship.
them- let
We'll
them
give
go.
them our list.
Let
We have
them
not
sit,
made a
let
list.
them sit in their library. Let them go to the relevant part.
Yes.
You just point out the relevant.
I have already given the list. So.
Similarly, you also give your list.
Yes.
You, Mr. Pasquale, so
The
exchange.
other connected matters emanating from the said affair are listed on 20th of this month. Is the matter?
But then there is not.
Not
Mr.
related
Jindal
to
is not
this.
appearing in those matters.
No, I am not appearing.
Let us see. Let us see. Their stand may be different. Because stay is granted in that matter.
Yes.
Here no stay is granted. So there is an assumption Mr. Jindal is in weaker footings. May not be. Yes.
Your Lordship.
Deeply obliged.